Hello everyone, welcome to the first part of our two-part webinar series discussing significant construction and adjudication cases of 2021. And these two webinars aim to cover key developments in construction and adjudication practice and how these might affect your construction project disputes in 2022. Now, today's webinar will focus on our chosen top 5 construction cases of 2021, and we will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. This webinar is pre-recorded. However, if you would like to ask a question, we'd be very happy to address any queries after the webinar by telephone or by email, and our contact details are noted on the next slide for you to use. So your speakers today, I'm Ian Drummond, a partner specialising in construction and engineering dispute resolution at Shepherd and Wedderburn, and I'm joined by my colleagues Sean White and Lisa Ambrose, who are both solicitors in the construction and engineering disputes team. Our team regularly advises on construction contract issues and disputes across a range of projects and industries, so we therefore have a great deal of experience in litigation, arbitration, adjudication and mediation in those areas, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. I will now pass you over to Sean, who will run through the agenda for today's webinar.
Thank you, Ian. So the first case that we will discuss today is Van Oord UK Limited against Dragados UK Limited, in which the Appeal Division of the Court of Session in Scotland interpreted the NEC 3 obligation that parties act in a spirit of mutual trust and cooperation. We will then consider the English Court of Appeal's decision in Building Design Partnership against Standard Life Assurance Limited. The court in that case confirmed the appropriateness of sampling in defects claims, but also discussed some of the risks involved with that approach. Our third case is Shanghai Shipyard Company Limited against Rainweed International Investment Group Company Limited, in which the English Court of Appeal carefully considered the wording of a parent company guarantee to assess whether it was payable on demand or only once breach had been proven. Our final two cases relate to liquidated damages, and those are Triple Point Technology against PTT Public Company Limited and EcoWorld Ballimore Embassy Gardens Company Limited against Dobler UK Limited. So firstly, turning to the Scottish Inner House decision in Van Oord, which concerned the interpretation of a contract based on the NEC 3 standard form. The works related to dredging of Nig Bay, which was part of the Aberdeen Harbour expansion project. Dragados, the main contractor, was employed by Aberdeen Harbour Board and subcontracted all dredging works to Van Oord. Despite its subcontract with Van Oord, Dragados then transferred a third of the dredging works to 2 other subcontractors. It issued instructions for Van Oord to omit these works. The subcontract was later terminated with much of the work incomplete and with parties disputing the correct valuation of the termination account. Van Oord sought payment of the original bill rate for the omitted work, but Dragados sought to reduce the sum payable under the subcontract by 49%, in line with the NEC 3 compensation event provisions, particularly clause 63.10, which provides that if the effect of a compensation event which changes the work's information is to reduce the total defined cost, then the prices are reduced. Van Oord argued that Dragados had knowingly manipulated the contract in its favour. At tender stage, Dragados had insisted on bill rates that reflected an average of easier and harder works. Van Oord had accepted this on the premise of carrying out all such works. However, Dragados had in fact benefited by transferring away easier works, leaving Van Oord with a disproportionate share of difficult works paid at an average rate. Dragados accepted that it had breached the subcontract when it transferred the works. The issue that remained was whether Dragados was entitled to reduce the bill rate payable to Van Oord for the remaining works. The court considered the following. 1. whether non-compliance with the good faith clause 10.1 in NEC 3 could bar a party from benefiting from the price reductions under clause 63.10, and 2, whether in this instance the prices ought to be reduced, taking account Dragados's breach of the subcontract. So considering the first of those issues, could non-compliance with clause 10.1 prevent a party from obtaining a reduction to the prices under clause 63.10? The Inner House gave careful consideration both to the price reduction mechanism and, importantly, to clause 10.1, which provides the contractor and the subcontractor shall act as stated in this subcontract and in a spirit of mutual trust and cooperation. Whereas the court at first instance considered that clause 10.1 did not add much, on appeal, the court held that it reflects and reinforces the general principle of good faith in contract. Clause 10.1 is not merely an avowal of aspiration. The court stated that the clause aligns with 3 specific propositions derived from case law. Number 1, that a contracting party will not, in normal circumstances, be able to take advantage of its own breach against another party. Number 2, that a subcontractor is not obliged to obey an instruction issued in breach of contract. And number 3, that clear language is required to place one party to a contract completely at the mercy of another. The court stated that the first of those propositions embodies the doctrine of mutuality. A party cannot enforce a contractual stipulation in its favour if it is the counterpart of another obligation which it has breached. The court found that the requirement of good faith under clause 10.1 was a contractual counterpart of clause 63.10. That confirmed that unless Dragados had fulfilled its duty to act in a spirit of mutual trust and cooperation, it could not seek to reduce the prices. Whether Dragados fell foul of clause 10.1 will be subject to an evidential hearing in due course, but irrespective of the outcome, the principle that the NEC good faith clause is given parity with other contractual provisions now has judicial approval from the appeal court in Scotland. This will of course be persuasive, albeit not binding in the rest of the UK. Turning to consider the second issue before the court, did Dragados's breach of the subcontract, which was not disputed, allow for a reduction of the bill rate payable for the remaining work? As mentioned, clause 63.10 allows for a reduction of the prices when a compensation event changes the work's information and leads to a reduction in the total defined cost incurred. Van Oord's defined costs were clearly reduced by the de-scoped works, but the court concluded that this did not reduce the contract prices, that is, the price to be paid by Dragados. The court held that clause 63.10 only applied where the contractual change that reduced defined costs was lawful. A breach instruction, like that given by Dragados to omit works, did not fulfill the requirement that it be given in accordance with the subcontract, which is provided for in clauses 14.3 and 27.3 of NEC 3. It was therefore invalid. The court indicated that NEC 3 should not be a charter for contract breaking. So what conclusions can we draw from the decision? Van Oord against Dragados is an example of the appeal court in Scotland giving good faith a prominent role in contractual interpretation. It is a binding obligation and not merely a statement of aspiration. The decision continues a long, if slow, trend of greater emphasis for good faith in commercial contracts. The Inner House decision impacts on how the good faith clause in NEC 3 and its equivalent in NEC 4 will be interpreted. Whether this analysis is extended beyond NEC contracts remains to be seen. However, the Inner House was clear that clause 10.1 does not impose good faith provisions, but rather reflects and reinforces them. I will now pass you over to Lisa, who will cover our second case.
Thanks, Ron. So the second case that we will discuss today is Building Design Partnership against Standard Life Assurance Limited, in which the English Court of Appeal considered whether a party could plead a case on professional negligence on the basis of sample and extrapolation. So in this case, Standard Life entered into a building contract for a mixed retail and residential development in Newbury in Berkshire, with Costain as its main contractor. The contract price was £77.4 million, but Standard Life ultimately paid £146.4 million to settle the final account. That amount included £28.4 million in respect of variations to the building contract. Standard Life subsequently brought a claim for professional negligence against 6 members of its design team for a sum of £38.1 million. Standard Life claimed that the design team had carried out its work on the development negligently, issuing 3,600 instructions to Costain that consequently resulted in the final account increasing by over £38 million. This was its primary case. Standard Life's particulars of claim did not set out all 3,600 instructions to Costain. Instead, it relied upon extrapolation from a selected sample of instructions, which it claimed it had analysed in detail. It argued that the court's findings on these 122 samples, covering 4 areas of work, could be extrapolated in order to draw inferences on the remaining instructions. The selected sample related to around £12.9 million of the £38 million claim. Standard Life argued that this was a reasonable and proportionate approach, and that requiring it to plead and prove every part of the claim would be disproportionate and absurd. 3 of the 6 defendants, BDP, Sutton Griffin Architects, and Cundall, the design team, argued that the sampling was not appropriate. Firstly, they argued that given the pleadings were limited to this specific sample of £12.9 million, Standard Life had failed to plead a case in relation to the balance of the claim, which was just over £25 million. They also argued that the sample taken was not appropriate, as it targeted the high value variations in order to maximise Standard Life's claim. Finally, the design team took issue with the manner in which the case had been pled, claiming the pleading was vague and incoherent. So what did the Court of Appeal decide? Well, the Court of Appeal confirmed that the extrapolated claim is a proportionate way of addressing the 3,437 uninvestigated variations. However, it did make clear that a court would not blindly accept a claimant's proposed extrapolation. Rather, the court would always consider the full circumstances of a claim to assess whether a party had proven its case. The court said, like any other step taken to save costs, it may make the claim more difficult to establish at trial, but that is an inherent part of the trade-off which any claimant has to negotiate between saving costs by not doing things, which if money were no object, it might have done, and maintaining a realistic prospect of ultimate success. So what can we take from the court's decision? The court has reiterated that the use of sampling and extrapolation is acceptable as a way of corralling evidence and keeping trials within proportionate limits. That said, there are downsides to a claimant taking this approach. Particularly, it might be difficult to prove its entire claim, and careful consideration should be given to the basis on which a claimant can argue the relevance of the sample taken. Ultimately, that is a balance to be drawn and a decision to be made by the claimant, which entails risk for the claimant in proving its case.
Thank you, Lisa. Our third construction case of 2021 is Shanghai Shipyard Co. Limited against Rainwood International Investment Group Company Limited. In this case, the Court of Appeal considered whether a parent company guarantee was an on-demand guarantee or a see-to-it guarantee. Firstly, I'll give a brief reminder of how these guarantees work. In construction projects where a subsidiary company enters into a contract with a third party, it is common for the third party to request a parent company guarantee to ensure the performance of the contract. Now, typically, these guarantees are intended to protect employers against contractor insolvency. However, they are also sometimes obtained in respect of employers whose financial covenant is uncertain. Where an on-demand guarantee is entered into, the obligation to pay arises immediately in the event of a default and upon a demand being made under the guarantee. In contrast, a see-to-it guarantee is a secondary obligation. It is necessary to establish liability before the beneficiary is entitled to benefit from the guarantee. So I'll now look at the facts of this case. Shanghai Shipyard, the builder, entered into a bespoke contract with a special purpose company, the buyer, for the construction of an offshore drill ship for $200 million. Investment company Rainwood acquired an indirect shareholding in the buyer, and Rainwood funded payment of the first $30 million installment due by the buyer to Shanghai Shipyard under the contract. And Rainwood also provided a payment guarantee in respect of the remaining £170 million final installment that would be due by the buyer. The buyer ultimately refused to take delivery of the drill ship, however, on the basis that it was alleged to be defective, and the buyer therefore defaulted on payment. So Rainwood was called upon to pay under its guarantee. However, Rainwood failed to pay, and meantime the buyer commenced arbitration proceedings against Shanghai Shipyard under the contract to determine whether the ship was in a deliverable condition. Shanghai Shipyard then, in turn, commenced proceedings against Rainwood in the High Court to enforce the guarantee. Clause 4 of the contract contained an arbitration carve-out, providing that in the event of a dispute being arbitrated between Shanghai Shipyard, the builder, and the buyer, then Rainwood, as guarantor, would be entitled to withhold payment of the guarantee sums pending the outcome of the arbitration. But that would be only if the arbitration had commenced at the time the demand was made, or regardless of when such arbitration is or may be commenced. Shanghai Shipyard argued that the guarantee was on demand and that the arbitration had not been raised in a timely manner. But Rainwood in turn argued that the guarantee was a see-to-it guarantee and that it had no obligation to pay because the clause 4 was engaged, the arbitration had concluded, and the award was made. Meantime, the drill ship remained in the possession of Shanghai Shipyard. The court at first instance agreed that the guarantee was not an on-demand guarantee, but was a see-to-it guarantee. And in arriving at that decision, the court applied a presumption against interpreting guarantees as on-demand guarantees. Unsurprisingly, Shanghai Shipyard appealed because that decision had potentially significant consequences for guarantees in the marketplace. And indeed, the Court of Appeal reversed the first instance decision in holding that the guarantee was on demand and that Rainwood was obliged to pay. The Court of Appeal carefully examined the wording in the guarantee, and the following wording which it contained was particularly significant. It stated, "We," which is Rainwood, "hereby irrevocably, absolutely, and unconditionally guarantee, in accordance with the terms hereof, as the primary obliger and not merely as the surety, the due and punctual payment by the owner of the final installment of the contract price, amounting to a total sum of $170 million US." And it also stated, "Upon receipt by us of your first written demand, we shall immediately pay to you," etc. So the Court of Appeal held that these words were absolutely key. In particular, the use of the words absolutely and unconditionally pointed away from a requirement to first establish liability of the buyer before the guarantee could be called upon. Furthermore, the words "as primary obliger and not merely as surety" were a clear indicator that it was not a see-to-it guarantee. And in addition, the words "upon receipt by us of your first written demand, we shall immediately pay to you" were also the hallmark of a demand guarantee. So the Court of Appeal said payment was due, it was an on-demand guarantee, and it gave no effect to the clause 4 arbitration carve-out because arbitration proceedings had been issued after the demand for payment under the guarantee had been made. So, in summary, what are the takeaways from this rather complex case, or at least it was complex on the facts? Well, the arbitration carve-out clause actually reinforced the position that the guarantee was on demand because absent a timely reference to arbitration, a payment requested under the guarantee was unconditional. I think this decision is a timely reminder of the need to consider whether guarantees which are being granted are on demand or see to it. Clearly, the difference between them is significant, and it has significant consequences both for those relying on them and those for granting them. And the wording of such guarantees can often point to a different conclusion from what was first understood. So the terminology of guarantees need to be carefully considered by those who provide them and those who obtain them to make sure that that terminology clearly reflects the intended status of the guarantee. And just as a last observation, we find that these sorts of documents often contain antiquated and unclear terminology, which is usually unhelpful and obscures their meaning.
Thank you, Ian. So our fourth and fifth cases both concern liquidated damages. I'll start by reminding listeners that liquidated damages, or LDs, are predetermined damages set at the point a contract is entered into. In construction contracts, they are generally levied by an employer on a contractor when the contractor has not completed its works timelessly. Our fourth case then is Triple Point Technology against PTT Public Company Limited, in which the UK Supreme Court was required to determine whether liquidated damages applied following termination of a contract. In this case, a second contractor having been engaged to complete the works. PTT, a commodities trader, placed an order with Triple Point, a software system supplier, for a new software system dealing with trading, risk management, and vessel chartering. The project contract provided for payment against certain milestones in the works, and it applied LDs in the event of particular delays. Payments were issued in respect of the first two stages of work. The project was then subject to delay, and Triple Point failed to complete any of the further stages. Triple Point sought payment of software license fees from PTT. This was refused because no further stages in the works, and therefore no payment milestones had been reached. Triple Point suspended work pending payment and left the site. PTT argued that this was a wrongful suspension of work. It served notice requiring Triple Point to remedy its breaches of contract, and when Triple Point did not comply with the notice, PTT formally terminated the contract and engaged another contractor to complete the works. Triple Point sued in respect of its invoices and work it had carried out prior to termination. PTT counterclaimed for damages, including LDs. The questions before the Technology and Construction Court, or the TCC, being the court of first instance, were 1. Whether Triple Point was entitled to cease works pending payment. 2. Who was responsible for the delay. 3. Whether PTT was entitled to terminate the contract. And finally, 4. To what extent LDs were payable and were they subject to a liability cap. The TCC held that Triple Point was not entitled to suspend works and that it was in breach of contract. Triple Point were responsible for the delay and PTT was entitled to terminate the contract. PTT was awarded approximately $3.5 million in LDs for delay up to the date of termination, as well as other incurred costs. The court found the contractual cap on liability did not extend to cover LDs. This decision would potentially have major ramifications across the construction industry, as it remained uncertain whether LD clauses would be held to apply only up until the date of termination or until a second contractor achieves completion. Unsurprisingly, the decision was appealed and the Court of Appeal addressed this issue. It held that LDs were not due for the period beyond termination of the contract and that PTT was entitled to liquidated damages in respect of completed and accepted works only. Significantly, the Court of Appeal held that liquidated damages did not apply in respect of incomplete works. On the question of whether any contractual limitation of liability applied to these LDs, the Court held that the relevant clause did create an overall cap on the extent of Triple Point's total liability, which included its liability for LDs. So the established position that LDs are payable for incomplete works up to the date the contract is terminated and that ascertained damages are recoverable thereafter was thus cast in doubt. The significance of the points raised led to a further appeal to the UK Supreme Court. The Supreme Court unanimously rejected the Court of Appeal's decision, holding that the effective LD provisions should normally finish when a contract is terminated, but importantly, should apply to incomplete works up to that date, not only those works that were completed and accepted. It agreed that the contractual cap in this case extended to cover LDs. So the points to take away from this decision, the first is that clearly LDs can be hugely important. Contractual provisions relating to them require careful drafting. The application and effect of these clauses will depend on the precise wording used, but certainly the consequences of the way in which they are drafted can be significant. The Supreme Court's decision confirms that accrued rights and liabilities may survive termination of a contract, and that subject to clear and express words to the contrary, entitlement to LDs normally accrues up to the date of any termination. Thereafter, only general damages will apply. In addition, whether the accrual of LDs in these circumstances may be limited by a contractual cap on liability will depend on the precise wording of the relevant provisions. The decision provides greater certainty to both employers and contractors that they can rely on existing LD clauses with confidence. Now, Lisa will discuss our final case for today.
Thanks, Sean. So our fifth and final construction case of 2021 that we are going to cover today is EcoWorld, which is Ballymore Embassy Gardens Co Limited against Dobler UK Limited. This case concerns the enforceability of an LD's provision where there was partial possession of completed sections of a development. As I will outline, the case highlights the need for parties to consider whether their contract should include a mechanism for levels of liquidated damages to vary in the instance of a party exercising a right to early possession of a construction project. So just to give some background to this case, the employer, who was EcoWorld, engaged the contractor to carry out the design, supply and installation of facade and glazing works on 3 residential tower blocks in London. Levels of liquidated damages were agreed at the point of entering into the contract. LDs were set as 0 for the first 4 weeks of delay and £25,000 per week thereafter, subject to a cap of 7% of the final contract sum. The contract permitted the claimant to take over possession of the works prior to practical completion, and the claimant did so in relation to 2 of the tower blocks in June of 2018. Practical completion was then achieved in December 2018, 16 months after the agreed completion date in April 2017. The amount of LDs payable for the delay was disputed by the parties, and the case was subject to 3 adjudications before proceedings were raised in the Technology and Construction Court. We won't consider the decisions in the adjudications today, but rather the point considered by the TCC, which was the application of the liquidated damages clause in the contract. So in the TCC case, EcoWorld sought the following declarations. Firstly, that liquidated damages as agreed in the contract were valid and or that they were enforceable, irrespective of whether the claimants had taken early possession. And secondly, EcoWorld sought a declaration that said if the liquidated damages clause was void and or unenforceable, then EcoWorld was still entitled to claim damages for delay. In relation to the first point, the TCC held that the contractual clauses on liquidated damages were valid and enforceable, notwithstanding early possession. The lack of contractual provision for reduction of LDs upon early possession did not change this. Further, the court held that the LDs clause was not a penalty, as it was not out of proportion to EcoWorld's legitimate interest in securing timely completion. In relation to the second declaration sought, the court held that if the liquidated damages clause had been found to be unenforceable, EcoWorld would be able to claim general unascertained damages, but these would be subject to the 7% cap set out in the contract. So points to note in this case makes it clear that following other recent case law, the courts are unlikely to hold that a liquidated damages clause is a penalty unless it is all out of proportion to the legitimate interests in securing timely completion for the employer and is not commercially justifiable. It's clear that there is a need for careful consideration of whether contracts should include a mechanism for levels of liquidated damages to vary in the instance of a party exercising a right to early possession in terms of a construction project. Although in this case, LDs were proportionately reduced to account for the early possession, despite the clause not providing for this, parties may wish to amend contracts to include a pre-agreed reduction of LDs for early possession, just to avoid such disputes. I'll now pass back over to Ian, who will cover the lessons learned in today's webinar.
Thanks, Lisa. So I'll now provide a summary roundup of the main points that we take from our 5 construction cases that we've covered today. So firstly, the NEC obligation to act in a spirit of mutual trust and cooperation is not merely aspirational, but reflects a general principle of good faith in contract. And I think we can probably see this being used quite a lot in the forthcoming year in contractual arguments and adjudications. Secondly, in defects and variation claims, it may be appropriate to use sampling, but consideration should be given as to whether the cost-saving benefit of doing so is worth the risk that a decision maker will not agree with the approach taken to extrapolation, and that elements of the claim therefore may not be proved. So, proving a case by extrapolation has been accepted to be possible, but it entails a risk, in other words. Thirdly, careful consideration should be given to the wording of a parent company guarantee, as that will be a crucial factor in determining whether the guarantee is payable on demand. And as we commented earlier, it's particularly important to have a look at these documents where they're being granted or received, because they do often contain antiquated wording, which is difficult to follow and can obscure the potential meaning and effect of the guarantee that's been granted. Fourthly, liquidated damages will generally accrue up to the date of any termination of a contract, after which unascertained, i.e. general damages, may apply. And that position seems fairly well settled now, as that's what was decided by the Supreme Court after processes of appeal through the various courts where these issues have been closely considered. And then finally, at the time of contracting, careful consideration should be given to the operation of liquidated damages clauses in the event of partial takeover. A liquidated damages clause is unlikely to be considered a penalty unless it is out of proportion to the legitimate interests in securing timely completion and is not commercially justifiable. Merely because works are taken over early or partially does not mean a liquidated damages clause will be invalid if it does not provide for that situation. However, clearly that entails a risk, and it's better to draft for that position in advance. So we've now come to the end of today's webinar, and we hope that this has been an informative look at some of the most important construction cases decided last year. If you do have any questions about the discussion today, or any related topics, then please do feel free to get in touch with us. Thank you all for listening, and we hope you will join us again at some of our future webinars in 2022, in particular, the second webinar of this series, which will be coming soon. Thanks very much for listening.